It really comes down to, is it reasonable? And one of the factors is, what is the rule of reason?
Welcome back to Visa Vibes, where we try to keep you updated on what's going on with business immigration these days. And today we're diving into a topic that's really affecting thousands of employers and skilled workers: PERM labor certification delays.
Yeah, and this one's a little bit personal for me. Just recently, I was up in Boston in the at the First Circuit Court of Appeals, challenging the Department of Labor's ever-growing backlog and delays in adjudicating PERM applications. So we're going to unpack what's going on, what the Court of Appeals seemed interested in, and what could be next in the world of litigation.
All right, so let's give a little background here first. PERM, what the heck is it? It is the first step for most employment-based green card processes. So this is a way a company sponsors someone for a green card. Not every single employment-based green card requires a PERM, but the majority of them do. And so without it, you cannot move on to the second step of the green card process, which is the I-140 petition.
Yeah, and so, Congress created, not Congress didn't create the PERM system, but they mandated this labor market test to require employers to test the labor market to make sure that there are no qualified U.S. workers available to perform the role before a company can sponsor. And so the problem is, what used to be a very quick process, a couple of weeks process, has now turned into a 16 to 18 month backlog, a delay, and that doesn't include the prevailing wage, which is delayed. You've got to do the recruitment, the quiet period, all that. And this is a huge shift from what DOL promised when they created the regulation. So in 2004, the process of PERM was created. This was to an attempt in the regulation to federalize the system, okay, and organize the PERM labor certification system. And it was designed to let the computers do the PERM. It's really just, you fill out some boxes on there with what you do. And they had created an anticipated goal of 45 to 60 days to do the PERMs. Okay, and this is 2004. Ironically, actually, when they originally uh, proposed the rule, it was only like 21 days, and the final rule was 45 to 60. And I know historically that used to be okay. They were well ahead. The idea was the computers would do the whole process. They would program in some audit barriers. These types of things would flag for audit. And then we'd audit another, X percent. And then humans would take over the audited cases, but the non-audited would just be the computers that do it. Um, and that's why they could commit to such a quick process. Again, 2004, 45 to 60 days. And Emily, I've joked since we started talking about litigation on this that we can all assume that the technology is better from 2004. So I did a little bit of diving in here for our listeners. So in 2004, we saw the launch of the Facebook at Harvard. Okay, not Facebook, the Facebook with Mark Zuckerberg from the good movie we've seen. The iPod Mini was released in 2004. Okay. The major cell phone breakthrough was 1 megapixel cameras on cell phones. So we could finally take blurry concert pictures. And Skype was just released the year
Oh, yeah,
before.
I remember Skype.
So it's entirely possible Department of Labor is still running Windows XP, okay? But I think we can all agree the technology is approved.
Yeah, and I was practicing when Perm came out, and it was such a breath of fresh air because before that, every labor certification depended on which state you were in, and some state workforce agencies were faster than others. Some, like Texas, were taking 4 years to get a labor certification, and then others, like Ohio, were taking just a couple of months or a year. So they federalized it all, made it all one nationwide processing time, and we were getting approvals in a day,
Right.
1 day. It was like, it was amazing. And it kept like that for quite some time. It was very reliable, great process for the beginning.
Well, and believe it or not, that was actually one of the things we partially challenged in the litigation is that this whole delay frustrates the whole intent of the program, right? If the idea is to test the labor market, well, when you do recruitment 500 days before, we know the labor market changes over the course of a year and a half. So is it really an accurate test? Or are we just doing it to go through the process? And so it's
Yeah.
not what Congress intended, which is why DOL said, hey, 45 to 60 days, that's testing the labor market.
Yeah. And the other benefit of a faster process is if something was done wrongly, because it is computer driven, and if you checked the wrong box on the form or the wrong date was entered, because the dates are very specific and very restricted, and you got a denial, your advertisements, your recruitment was still valid to where you could simply turn around and refile. And that is not an option anymore.
No, like God bless our perm team. Like I don't have the patience to go through and make sure every comma is correct,
Yeah.
like they do.
They have to go through it with a fine tooth comb because it is such a mess if it ultimately gets denied a year and a half later and now we have to start over
Yeah.
from scratch. So, what is causing this bottleneck? Is it the demand? Are there just so many more perm filings that the computer can't keep up?
That's what DOL kind of wants you to think. According to the Department of Labor, it's staffing shortages and rising case volume. I don't think that's true. All right. Our litigation records show something different. First, in the 2004 regulation, in the comments, they say, hey, this 45 to 60 days, we're anticipating about 100,000 filings. Now, there are some years that we've gone over the 100,000. I think fiscal year 2022, 2023, we're about 116, 120,000. So if we took 45 to 60 days plus 20%, that would make sense, but it's certainly not the 10 times increase that we're seeing. What's even crazier, we've seen a huge jump in the last fiscal year 2024, where we now hit that 500-day mark. Only 95,000 perms were filed, so less than what they anticipated. The other thing that's interesting, I think probably the most frustrating for any business that I've talked to about this, is they have a commitment of 11 to 13 minutes per perm application. That is what they're kind of contractually obligated as employees to do. And the administrator that oversees all this was so proud when we deposed him. He said, you know what they did last quarter, the one right before, we deposed him? 8 minutes. And every time we talked about it, it was like 8 minutes, 8 minutes. So they're taking 8 minutes because all they're looking for is completion. And now we're at 500 days. Like that's ridiculous. So a couple of other things stood out in the notice and comment rulemaking for PERM. DOL said we were going to do things on a first in, first out. And in litigation, they changed that. We all of a sudden hear about this month processing thing where cases filed in June of 2024 get adjudicated in the same month. But there's a lot of inconsistencies. We hired a statistician to go through this and look at this and saw cases weren't being filed in the same or adjudicated in the same month batching, that there was all this line jumping. And that's why we hired, is because we have all the data from Department of Labor. And when we bring delay cases, like the government likes to go line jumping. They're just trying to jump the line. Well, when we can show there is no real line and everybody jumps the line, it's problematic.
Yeah, so you could ultimately, file two cases for two people on the exact same day, and the adjudication would happen hundreds of days apart,
Mhm.
which makes it very difficult for people to plan their lives, know what to expect in terms of being able to get that H-1B extension beyond the 6th year when you need the labor certification to be approved so you can get the I-140 approved so you can file your extension. And some of these do go down to the wire where,
Yeah, yeah.
2 days before the H-1Bs expire and we get the I-140 approval and we hurry up and turn around and file. Well, if there's no rhyme or reason to how long it's going to take, we really can't plan ahead for that.
So I want to talk about how long we think perms should take. So first off, the answer I think is pretty clear. And this was something the courts asked, that in the regulation, they said, we're going to do this 45 to 60 days. And Department of Labor's defense is that's aspirational. Okay, so maybe it is. Maybe that is aspirational. One of the judges on the panel asked, so what does that mean? Like it has to mean something. And he went, well, it's irrelevant.
Mm.
Well, the Administrative Procedure Act still requires them to act in a reasonable amount of time and is 500 days reasonable? I don't necessarily think so, especially when they said with the same amount of demand and their resources have stayed steady. It's not like they're losing money. It's not like it's a shift in priorities. There's no reason they couldn't do what they committed to if they ran the program efficiently.
Yeah, and again, 500 days later, the labor market is looking way different than it did at the time of filing. You want these to be adjudicated at the time of the labor market test, not months later. And this really matters because it affects lives, it affects businesses. People are not able to continue to employ the workers that they rely on if they lose eligibility for H-1 extensions. Or we saw a lot of situations, October 2020, when
Mhm.
the visa bulletin unexpectedly jumped way forward and people were in the early ages of their stages of their perm filing. Well, those dates moved backwards by January 2021. And so if you didn't have your new perm in place by then, because long processing times, you missed the boat. So many people missed that boat and are still waiting to get on the boat from 5 years ago.
And I brought that point up, exactly that October 2020 point that, again, when we look at that time period, if they stuck with that 45 to 60 days, all of them would have been able to file, during the window when things before it retrogressed.
Yeah, and then, with the perm labor certification process, you are filing for a particular position. So you have to determine what is the position that this person is being sponsored for, what are the minimum requirements, what education is needed, are there any special skills? All of that is set out at the very beginning of the process when you submit your prevailing wage. And so a lot of people are fearful of taking promotions
Hmm.
during this whole process because they worry that they're going to have to start over again. And so if you are delaying this process to where it takes 2 years to make it through it, 3 years, just think how many people are, avoiding moving up in their company because of it.
Yeah, and I think to that point, it frustrates some of the ideals of AC 21. Congress, okay, we've got a backlog and we're not going to fix it, so we'll just put a band-aid on it. And Congress wanted to increase, transfers and more job mobility and portability and allowing people to take promotions, seek better job opportunities so they're not kind of stuck. But you're stuck with a process that takes 500 days plus the PWD, which is taking months at a time, plus recruitment. It kind of keeps everybody stuck where they are.
All right, so let's talk about your litigation
Yeah.
case.
So, full transparency, why are we at the First Circuit Court of Appeals? Well, we lost, right? At the district court. Now, I don't think the reason we appealed is because I think there's a lot of issues with the decision from the district court. We had some procedural issues, but also the analysis that was done. And we asked the First Circuit Court of Appeals to overturn it, rule that delays beyond the 60 days were unreasonable. And we also, challenged the way the district court went about its analysis.
So, what did these judges seem to be most interested in?
Yeah, so big topic was mootness, which we're not going to talk about on here because I think that's kind of boring for our listeners. All of our plaintiffs had gotten their perm and they're like, why are we still appealing? Like, what can we do? And we talked about the promotion thing, that they're going to have to go through this again. But from the merits of it, there were two things that really stood out from the judges. One, whether Department of Labor has a rule of reason that guides its processing times. When we talk about APA delay cases, writ of mandamus, whatever, it really comes down to, is it reasonable? And one of the factors is, what is the rule of reason? And so, you look at USCIS and they say, well, we do things on a first in, first out basis. And the judge is like, yeah, sure you do. Like, that's definitely cool, until they actually look into it, right? But the district court said, hey, they follow this month processing time, and it doesn't really matter that in the rulemaking they said they were going to do the month processing. The appeals court brought up two things. They said, one, this change of adjudication method without anybody knowing was a concern. Uh, I had talked to a lot of lawyers that do perms. In our firm, other firms, nobody had heard of this month batching until we deposed the government on it. Uh, but more importantly, and this is a big part of it, is you can't just say you have a rule of reason. You have to follow a rule of reason. So, a rule of reason that isn't followed isn't a rule of reason. You can't just say, well, we do things this way when you don't. That's not a rule of reason. That's something we challenged. The other issue that the Court of Appeals was curious on was the district court's reliance on the posted processing times. That's another common tactic the government does in litigation. They say, well, Judge, like, look at our processing times. They say 500 days, so anything less than that is totally reasonable. And there are a lot of courts that have said no, like that's not how to do this. And it's actually very interesting. The Sixth Circuit in an immigration delay case, it was a U visa case, said that they find the processing times unhelpful to look at what's reasonable because it says little about what's reasonable, right? And their quote is, "We find it unhelpful to fixate on the average snail's pace when comparing snails against snails in a snail's race." That is in a Sixth Circuit opinion. And what they mean is 500 days might be their posted processing times, but that could be completely unreasonable. You can't just go on your website and says it takes 100 years to do a perm and be like, on our website, that's reasonable.
All right. So we had the argument in the First Circuit. What is the path forward from here?
Yeah, so the First Circuit has a few ways that they could handle this case here. One, they could rule on the mootness, which would get rid of the bad decision, and say, hey, everybody has everything. Procedurally, it's vacated, okay? But more importantly, I think they are going to potentially look into maybe some guidance. These cases are going to keep coming up. Processing times, some immigration delays, other APA issues that have delays are going to keep popping up. And the court has an opportunity to say this is how these analyses should be done. It's also possible more litigation is possible. If they do vacate this as moot, well, we'll be back fighting this, and we're ready to. The core of the issue is systemic. Courts have to hold Department of Labor reasonable, or delays are going to keep ballooning. Because if there's nobody holding them accountable, why would they work hard to do what they're supposed to do? I don't think the court's going to rule against us on the merits. I think they were pretty clear, like that analysis is flawed. I think it's possible that they might look at it and say, everybody has their perm. We can't really write this as an advisory, so we're just going to vacate that lower court opinion. And I'm hoping they don't, so we can see some guidance, on how to handle how the district court should handle these moving forwards. But if they don't, they just kind of do this on procedural grounds. We're ready to bring the next case. We wanted to see, how the First Circuit really found the argument. Because if they came in and they're like, Mr. Brown, you're completely garbage. Like this analysis is wholly inadequate. Maybe we need to rethink things. But they did say they have genuine concerns about the rule of reason and the processing.
Yeah, and this really was kind of a novel case. I mean, you've sued the government multiple times before, but never Department of Labor and never when it comes to perm
Right.
delays. There's lots of other delays that we've been successful on. So, coming up with the best way to bring forward the case and what types of plaintiffs to bring and all of that there's a lot of strategy going into that. So if this continues and we end up having to bring more litigation to where maybe employers or their employees might be willing to
Mhm.
be plaintiffs in a case, I would say they need to really think about preserving evidence of harm that they're facing due to these delays. Be ready to consult with legal counsel if delays are really becoming unreasonable, even more so than they are now, and just be prepared or consider that litigation could be an option moving forward.
Yeah, and I could tell you, I mean, again, to go back to our point, we lost at the district court level, but nobody was negatively impacted, right? And that's typically one thing I always talk about with litigation is that the government's not going to slow your case down because we're in litigation. And so even though the district court didn't rule it away, I think I would like to. I don't think they went in a way the First Circuit Court of Appeals would want them to. Nobody got slowed down, but hopefully moving forward, we can kind of force this to go quicker because again, the government hoped 45 to 60 days and now we're at 500 and there's no reason the computers can't knock out 100,000 perms in a day, to be honest with
Yeah.
you. So Emily, outside of the litigation, like let's talk practical, right? Like that you and I like being practical. It's one of our core values here at Reddy Newman Brown. What can employers and employees do with these perm delays?
Yeah, I think number one is to recognize that for now they are going to continue. Things are not going to get any better. They might get worse. So the best thing to do is to start the perm process early. Don't wait until year 5 of H-1B time to start the process. A lot of companies might wait until they filed that first H-1B extension, so where they're into year 4, 5, and 6. That may even be too late because right now, with the job market the way it is, it's becoming more difficult to make it through the recruitment process as well. And so, if you have to do the recruitment process more than once, you need to have that extra time built in to deal with the processing time, but also the potential for restarting recruitment and make sure that you're monitoring that 6 year limit clock for your H-1B holders. If you're doing this for those that are maybe on an L-1B, and definitely there's a 5 year limit there, you may need to consider converting them over to H-1B so that they can get that extra year on H plus extend beyond the 6 year limit. And then look at alternatives besides PERM. There are other categories of the green card that don't require perm. It's one of them is Schedule A for nurses and physical therapists. So if you have healthcare professionals, they can skip the perm process. National interest waiver is something that an employee could sponsor themselves for, and it does not require the perm process. EB1 categories, EB1A, extraordinary ability, EB1B, outstanding professor or researcher, or even EB1C, if you've got a multinational company, you could potentially send your employee overseas for a year to work as a manager or executive, bring them back maybe on an L or on an H, and then proceed with the EB1C green card process for managers or executives, because that category, at least for India, it's still backlogged, but only 3 years compared to EB2 or EB3. So
Yeah, getting that I-140 is critical, especially if they're on an H1. Obviously if they're on an L, doesn't help too much because apparently we're only going to do this for one category, but if they're on an H1, it has a lot of benefits of getting to the I-140 even with the backlog.
yeah, and then, if things do get delayed and you're not able to extend the H, start looking into what your options are and start looking into that early. If you think about it in your 5th year, before you get too close to the 6 year limit, there are options. You could potentially take strategic trips outside the US to be able to recapture time,
Mhm.
or you could stay outside the US until you get your I-140 approved and then come back on H. You could convert to another type of visa. Maybe you have an H4 EAD option if your spouse is also on H1B, or an L2 option, possible F1 option if you just want to take some time to study. You even have the option of a B2 if the gap period that you need from your max out time to the time that you get an approved I-140 to be able to do that extension, or until your perm has been pending 365 days. If that gap period is small enough, less than 6 months, you could use a B2 to kind of bridge the gap.
Yeah, and I think, one thing I want to make clear, because you mentioned the labor market test, and obviously it's, working as intended, right? We have more people looking for jobs that are American workers, and the Congress created that test to make sure they kind of get the first bite of the apple. But the perm delay litigation and the perm delay is completely outside of the recruitment. This is after recruitment is done and the 9089 is filed. And, at this point, Department of Labor is looking for completion. It's not, well, did you check everything? It's very rare, that. So completely disjointed steps here. But litigation is a tool, but proactive planning is most essential. I mean, think strategically, not just, oh hey, next year, Joe Smith maxes out. Like we should probably do something. Like that's not gonna work. I know for years we said, oh, start the perm before the 1 year, so you can get the 1 year extension. Now it's you might need to start that process 2, 3 years in advance. So think about long-term immigration planning, and a delayed perm doesn't have to be the end. It's just about creating what are our next steps because of what the world we're in right now with perm.
Yeah, so big takeaway, perm is certainly broken, is not working as it intended to be. What should have been a 60-day process is now taking a year and a half, creating a lot of issues for employees and companies. courts are hopefully looking
Hopefully.
into this and realizing that maybe it's unreasonable to wait that long. So we'll definitely keep you updated as more decisions come out and as new lawsuits are filed. And for now, thanks for tuning in to Visa Vibes.